हेलो फ्रेंड्स, नमस्कार। आज हम डिस्कस करेंगे एक लेटेस्ट कंट्रोवर्सी है और वो कंट्रोवर्सी काफी प्रैक्टिकल है और डे टू डे लाइफ में जो लोग जीएसटी रिफंड्स फाइल करते हैं उनके लिए काफी इंपॉर्टेंट है। फ्रेंड्स, मैं डिस्कस कर रहा हूं सेक्शन 54(1) ऑफ द सीजीएसटी एक्ट और रेड विद इट्स एक्सप्लेनेशंस। सेक्शन 54 ऑफ द जीएसटी एक्ट बेसिकली डील्स विद द फाइलिंग ऑफ जीएसटी रिफंड्स। रिफंड्स किन किन कंडीशंस में मिलता है, रिफंड्स की क्या टाइम लिमिट्स हैं, रिफंड्स कितने दिन में प्रोसेस होना चाहिए, एटसेट्रा एटसेट्रा। दीज ऑल आर द कंडीशंस व्हिच आर प्रिस्क्राइब्ड इन सेक्शन 54 ऑफ द सीजीएसटी एक्ट। तब आप पूछेंगे कि कंट्रोवर्सी लेटेस्ट क्या है। फ्रेंड्स, ऑनरेबल दिल्ली हाई कोर्ट आजकल एक पिटीशन पे हियरिंग कर रहा है, एक केस में डिस्कशन कर रहा है, आर्ग्यूमेंट्स हो रहे हैं, और वो है रिलेटेड टू टाइम लिमिट ऑफ फाइलिंग जीएसटी रिफंड। अब आप बोलेंगे कि जीएसटी का जो रिफंड है उसको जो फाइल करने की टाइम लिमिट वो तो 54(1) में इट्स गिवन इन द 54(1). सो 54(1) सेज any person claiming refund of tax interest if any paid on such taxes or any other amount paid by him may make an application before the expiry of 2 years from the relevant date. 54(1) categorically says that a refund has to be filed within 2 years from the relevant date. Now 54(3) says the refund of unutilized input tax credit shall be available in two situations. The first, the zero rated supply, and the second, the inverted duty structure where the rate of inputs is higher than the rate of output tax. Now the explanation, the relevant date is defined in the explanation to section 54, and after subsection 14, 54(14), the explanations are given, and the second explanation is related to the relevant date. Relevant date means yani explanation 2, the clause A, subclause Roman 1, 2, 3. They are defining what is the relevant date, and it goes from 54(14). After 54(14), it goes from explanation 1, 2, and the 2 has various clauses from A to H. And the interesting point is, the controversy is that 54(14) and the explanation 2E has been amended, friends, and it has been amended with effect from 1st of Feb 2019 with a notification number 2nd bar 2019. And before its amendment, this entry was worded like this, that in case of refund of unutilized input tax credit under subsection 3, the end of the financial years in which such claim of refund arises. Now let me explain you, because it has become very complex, and though it is very very complex, I will tell you how. The arguments in case of WPC number 12512/2021 and one more WPC 17538/2022, what the learned advocates are arguing, they are arguing that before this amendment, yani before 1st of Feb 2019, for the periods before this date, the refund applications for export were governed by explanation E to explanation number 2, 2E you can say. And they were saying that before amendment, they were not governed by 2A, they were governed by 2E. After amendment, now it is very very clear, crystal clear you can say. 2 is specifically dealing with unutilized input tax credit, 2A is specifically dealing with the refund of zero rated supplies. Honorable court has issued notices in this case, and the prima facie, you can say, the court seems in favor of the taxpayer, and the honorable court has not delivered its judgment yet, but they have indicated that the benefit of doubt should go in favor of the taxpayer, because they are not giving any benefit, but they are just making interpretation of an time limit, or they are granting relief only to the extent of limitation. They're not granting any kind of refund. And this matter, interestingly, has become so you can say complex. And the Honorable Court, in the open court, a few days back, the Honorable Court told to the senior advocate Tarun Gulati, also many other advocates also, they sought their expert advice on this, and the learned senior advocate is giving its advice to the court also. They are assisting the court, and they have given the a detailed chart comprising of the provisions of 5414 explanation 2A to E, how it can be read and how the benefit can be granted. So friend, this was a very important, you can say, the interpretation which will benefit a lot of taxpayers for whose 1718 to 1819 where the refunds have been rejected on account of limitation. This judgment, whenever it will be pronounced, it will be a very pragmatic judgment, and it will open the doors for the exporters whose refunds have been denied due to the limitation of 1718 and 1920. So with this, I conclude this video. Thank you very much for watching this video. Have a nice day.